I'm John Richmond from Richmond Vona, and today I'd like to talk to you about how personal injury lawsuits have been affected by COVID-19. Pursuant to an administrative order in late March by the Office of Court Administration, no new filings are allowed in New York courts. Now, there are some exceptions, and the order goes through these exceptions by court. Essentially, all these exceptions are those that the Office of Court Administration deems to be essential in these various courts. So for instance, it goes through and talks about what are deemed essential in civil housing court, in family court, in criminal court, and even in New York Supreme Court, where almost all personal injury lawsuits are inevitably filed in New York State. Now, in addition to these specific essential exceptions to this mandate that no new filings be made during this time period, there is a general sort of exception which says that if a court deems that your filing is essential, then it may then be filed. But of course, you have to go through your individual court, through your judge, and determine whether or not this type of filing is essential. Because this ban on filings applies not only to new lawsuits, but to different types of filings like motions that occurred during a pre-existing lawsuit. Now, this all came on the heels of Governor Cuomos' executive order, where he told or put a timeout on the statute of limitations or time in which you have to bring a new claim or file a new lawsuit until April 19th, 2020. Now, here at Richmond Vona, we anticipate this may be a little bit of a moving target, but the good thing is that during this time, you cannot be precluded later on from bringing a lawsuit if your time to file that claim would have expired during this statute of limitations pause issued by Governor Cuomo. So the big question is, what does this mean for personal injury lawsuits in New York State? Well, first off, as it pertains to existing lawsuits that have already been filed, that are already being litigated by lawyers throughout the state, it just means that you cannot file any new motions or other types of filings that are typical pursuant to a discovery order throughout the course of the case, unless your judge says that it's deemed essential and you're allowed to do it. However, there still are many ways in which lawyers are working together to push these cases along to resolution. For instance, if your law firm, as they should, has access to technology, they should be able to participate in video depositions, even video arbitrations or mediations. And we found in our experience to this time that actually both sides, the plaintiff and the defense, are working really well to push these cases forward. Now let's talk about how COVID-19 and this order will affect new potential personal injury cases. If you think you've been injured due to the negligence of somebody else and may have a personal injury claim, you really should call an experienced personal injury attorney right away. Even though your case may not be able to be filed, that attorney can still talk to you, understand the facts and circumstances surrounding your injury, get to know you and your family and how this has affected you, and start to prepare all the proper paperwork to get your case filed as soon as possible. All in all, whether you're an existing client of a personal injury law firm or somebody looking to hire a personal injury law firm, the administrative order shouldn't affect your law firm's ability to work on your case, to even investigate your case, to ultimately push your case towards resolution. Here at Richmond Vona, we're working tirelessly on behalf of our current clients and remain available to speak to new potential clients about ways in which we may be able to help. Please feel free to contact us at any time, 24/7, via email, text message. You can talk to somebody live on our website, and we'll be standing by ready to help.